right, we'll start at the top of the docket. So Donald Derby and Melanie Vianola. See Mr. Derby here. His height is
I'm here, Your Honor. Melanie Vianola.
Oh, there we are. Okay. Great. All right, I've signed an order for adequate cause, which we'll talk about at the end in terms of getting that to a hearing. There's been a report from the guardian ad litem, and I think today we need to look at what kind of parenting arrangement we'll have until we get to the hearing on the adequate cause. Mr. Derby, let me hear from you first, and then Ms. Height, and then we'll go to Ms. Vianola.
Good morning, Your Honor.
Good morning.
I'm hoping that my restraining order will stay in effect at least until we get some finalizing orders from the court. He seems to be doing so much better. He's happy. He's begging to stay at my house. I just feel like right now he's been at my house now for over 2 months, and he's really adjusting well. He's liking our routine. So I just hope that the courts will see that Tristan should stay with his father at this time. After he made that CPS report, his relationship with his mother got very volatile. So I'm just concerned. I don't want to see him go backwards.
Ms. Height, do you want to weigh in?
Yes. Good morning, Your Honor. I put a couple of recommendations in my report, as you saw, and I do think that it is probably short term in Tristan's best interest to remain where he is due to some of the disarray that's going on around him right now. I do have some other things I'd like to address with the court as I proceed with my investigation, but I think I'd like to hold off on those comments until after you've had a chance to hear from Ms. Vianola.
Okay. Ms. Vianola, any response?
Yes, Your Honor. I have not seen my son since it's been 2 months solid, and that was prior to a no contact order. And I missed a court date, which is obviously a horrible thing to have happen. And that is when I believe the no contact order came into play. But I don't understand why there was even a no contact order put into play, because I hadn't spoke to Donald via text, phone since March 21st. And it was about an email from the school. And that was the last time I contacted him. So also, the CPS report, there's no findings. And this is the third CPS report that he has filed against me. Well, one against my husband that was very, very awful, as well as the one that he claims on me. And there's no findings and no details. And the only thing I can really 100% say about my son is if something happens to him, or bad, he knows detail for detail, and that could be 10 years ago. He knows what you're wearing, what he had for breakfast. He is very, very meticulous when it comes to things that happen to him specifically. So I don't know how he can continue to violate the plan over and over and get basically rewarded for that. I mean, that's how I feel. He's had no consequences. I don't know what to file. I knew we were going to court, so I knew all this was going to come out. So I really just don't know what to file to say, look, he started this. December 8th was the first time that he started the withholding. And it turned in from just my weekends to solid 2 months. And then all this stuff happened. So I personally believe that Tristan would have a better shot if we both were supervised during this report and Tristan went and stayed with my father, who is a mutual person that Dawn feels is a safe home. Tristan has a great bond with, and we be supervised, because we've had 2 other GAL reports and nothing has changed. And except that things are being aggressively worse towards me. Like I'm becoming a more and more horrible person. It's not about Driston anymore, is how I feel. And that's it.
All right.
My father is here too as well, if you would like to speak with him at all.
Okay, I'm going to go back to Ms. Height first. Ms. Height.
Well, my comments now, Your Honor, are related to my concerns as the new GAL going forward. As Ms. Vianola just mentioned, I am now the third GAL that the court has appointed. As you can see by the date on the docket notice there, this case has been going on now for 10 years and 2 months. And as I look back over some of what's gone on before, I have not had time to read all of it, but I noticed, I made notes that there have been parenting plans, temporary parenting plans, amended parenting plans in 2013, 2014, 2015, 2019, 2021, and now here we are in 2023 with currently a 50-50 plan that it doesn't seem to be working. The record is littered with contempt allegations and charges. There's currently, as you know, this restraining order in place. There have been CPS reports, there have been allegations, accusations, denials throughout the pendency of this case. I have not read all of it yet, but of course I will. During all of this, we have now Driston. He's 15 and a half. He's a special boy. He has an IEP at Kelso High for academics and for behavior. He is, by all accounts, doing well in school right now. But he has seen and heard an appalling amount of adult conversation and, frankly, parental dysfunction over the length of his life. So as I approach this case, Your Honor, I believe that what I need to do in order to proceed and have a thorough, fair, complete investigation and a report for Your Honor is, I believe, after looking back at what we have up to this point, we need a level playing field here. And so this morning I'm asking for two things from Your Honor. First of all, I would like to have both parties have, by the end of today, I'd like to have them both go have a hair follicle 12-panel test with alcohol ETG. There have been allegations about drinking and fighting, and it seems like that's related to fighting. I need to know what's really going on. So I would like the court to order both parties to have a hair follicle 12-panel with ETG and no alteration of hair between now and then. Second, I would like them by end of workday tomorrow to both have made appointments to get a mental health evaluation with collateral input from me. I'd like them to sign ROIs. They can do that at Core Health or Columbia Wellness or wherever they would like to, but I would like to know that is underway immediately. The hair follicle test can be done over, the place that I believe can get to it right away would be Occupational Health over across from 15th Avenue Safeway. I pondered this morning whether there should be domestic violence evaluations, and I'm going to hold off on requesting that at this time. But I feel, Your Honor, that in order to do a fair evaluation, I need to get all of us on the same page. So those are my requests this morning, Your Honor.
What would be your thought of having a visit with the mother supervised by her father?
I am in favor of that. Driston is not. As you noted in my report, he said some rather, I would say, severe things during our interview. And I tried mightily to get some variation or some change on that. And that is one of the things I suggested to him and wondered if that would work. He adamantly said he did not want to do that. I personally feel like it's good for kids to have contact with both parents, and I would like him to do that. However, he was very, very stern about what he wanted and did not want. In fact, he did not want to have, even though I recommended it at the end of the day, he did not want to have phone contact either. And so I haven't been able to dig into the bottom of even why he feels the way he does, what's been going on, and what needs what needs to be addressed. So I feel like it's a good idea. I don't know how to make that happen without creating a bigger problem for him. He has been through a lot for a long time, and I'm very concerned about that. One last thing, Your Honor, before I let this piece go is, I know we are due for my final report on May 10th, and I don't think it's reasonable if Your Honor orders the things that I'm requesting today. I don't think it's realistic to expect that to be done and a report to be done and filed in a timely way. I'm going to ask for a delay of probably more realistic than a month. I probably should ask for 45 days beyond May 10th, which would put us more toward the end of June. And it bothers me. When I was talking about a May 10th deadline, it seemed like a more reasonable thing to say, well, let's just leave things as they are until May 10th. But when we're going all the way another 45 days past that, I do think that's an additional very long time for a mother not to have contact with her son. So that's the dilemma that I find myself in this morning, Your Honor.
All right, thank you. Mr. Derby, I'll give you the last word.
I have been trying to ask him if he wants to call his mother or his grandparents, and he's really, really adamantly just does not want to. And I don't know. I don't feel like I can force him to do it. You know, I've left it for him. He has his own phone. And talking about his own phone, last court, we both took an oath. We raised our right hands and said that we would tell the truth. And she said she had never talked with him at all and didn't even know his phone number. And that was false, because they'd been having text messages back and forth and talking, and he'd been calling his grandparents. So I just wanted the courts to know that too, on top of everything else. I felt
Recently were those contacts?
Excuse me?
How recent were those contacts by text messages?
Just before we started the adequate cause.
Oh, recently then.
Mm-hmm.
Okay.
And I think I asked him, I said, did you show your phone? You know, because I wanted him to show the phone so that way maybe the guardian ad litem could see that he had been in communication, and but his mother said that there was none and that I was keeping him from her, and that wasn't true. He has his own phone. He takes it to school. He has, you know, he can do whatever he wants with his phone. So I just wanted you to know that. He is definitely really concerned about being with his mother. And I don't know, there might be a lot more to this than what I even am aware of, because sometimes he's so resilient that sometimes he won't say something because he doesn't want to get someone else in trouble. He's a very nice boy, and I just feel like there's been more to this than what he's letting me know.
All right. Eventually, the contact with the mother may need to occur through some formal reunification counseling. And I'm sitting here, and part of me thinks that I should just require that there be a few hours of visitation during the week with the grandfather involved. But I think I've heard enough today that I might do more harm than good if I do that without some sort of formal counseling to get to that point. So I'm not going to order in-person visits. I am going to require, and this is going to be required on Tristan's part, one telephone call a week to his mother. And you can tell him the court is requiring that. Okay. And, you know, let's make it Thursday night at 7 p.m. That shouldn't get in the way of much in the way of people's activities. So I would like the message to go to Tristan that that's what I want.
Your Honor, I'm sorry to interrupt, Your Honor, but since Tristan and I had talked about this at a recent interview, would you allow me to notify him today of that?
Yes, you may do that.
Thank you.
And he has his phone on at school, and just so you know.
Okay,
And, you know, tell him they've got to chat about, you know, mundane things for at least 5 minutes.
okay,
You know, what's going on at school, what's happening here. You know, I also want to make sure that parents have contact with their children. But I want to be safe about it. Let's go on to some of the other issues. First of all, I'll have Ms. Height's final report due on June 28th.
okay,
Secondly, I am going to order the evaluations that she has requested. So that means today both parties are to get a 12-panel hair follicle test with an alcohol component. And by tomorrow, a mental health evaluation, if you can get in to do it at either Core Health or Columbia Wellness. Indicate that these are court ordered. Okay. Finally, has this been put on the trial setting calendar to get a trial date for the adequate cause hearing or the new parenting plan hearing? Mr. Derby, do you know?
I'm not aware of any new.
Okay. So what happens after I find adequate cause is that you go to the trial setting calendar and set a trial in order to relitigate the parenting plan. And that will be 6 to 8 weeks after you go to the trial setting conference. So I'm going to require and have everyone show up on the trial setting conference on May 10th. So Wednesday at 1 p.m. And that will need to be set after June 28th so that Ms. Height can complete her investigation.
Okay, Your Honor.
Now, the final thing I'm going to do, I'm going to set a review before this court on May 17th at 9 a.m. And I'm going to inquire. There's going to be one inquiry from me, and that is after several phone calls with Ms. Vianola, is it possible to have supervised visits after that date? And I just want to check in. I think going from now until likely sometime in July is a long time for Ms. Vianola to not see her son.
I agree.
And I want to be sensitive to what Justin wants, but I'm thinking if they have a few phone calls, maybe that will change. Also, there's some concern raised about making disparaging remarks to Tristan about the other parent. And that cannot be done. And if I hear of that again, that's going to be a significant concern. Okay.
Your Honor, if I might just trouble you for one more thing.
Sure.
Would you remind the parties to sign ROIs for both of those services? And if they would text me and let me know when their mental health evaluations are scheduled for, that will help me to plan the timing of my investigation going forward. I know those are small housekeeping details, but I think they'll be helpful for me. Thank you.
So at where you get the hair follicle test, you'll need to sign a release of information. We call it an ROI in favor of Ms. Height so she can get that document. And when you do an evaluation at either Columbia Wellness or Core Health, you'll need to sign a similar ROI. Okay. And then let her know when those are completed. Anything else, Ms. Height?
I think that's it this morning, Your Honor. Thank you very much.
Mr. Derby, anything else?
No, Your Honor.
Ms. Vianola? Thank you.
No, that's it. Thank you, Your Honor.
All right, we'll see you back here. There you go. Mr. Olson, you with us?
Yes, I am.
Great.
Can you hear me?
Yes. So this is a motion for adequate cause. And let me just pull up the file here. And that's brought by Ms. Johnson, or your current name is Steinweg?
Yeah.
Okay. So Ms. Steinweg, why don't you go first and explain why you feel I should sign an order for adequate cause, and then Mr. Olson can respond.
There's just been a significant change in Chris's behavior in the last year, at least. Chris used to be very involved in Zach's life in general. He would go to sporting events, he would go to doctor's appointments, things like that. And in the last year, he has been up to 40 minutes late picking him up. He's not involved in any of sports, doctor's appointments, anything like that. Zach has come home stating a lot of things about drugs and his dad overdosing. And recently he asked me why his dad would have him pee in a cup for him. Chris has lost his job, and I know that there's some medical issues going on, but that doesn't usually cause you to be late to pick up your child or, I guess, stop being so present in their life. So just a lot of concerns. And with summer coming up, I'm concerned that he has him a week on, week off, and there's been frequent times that he hasn't given him his medication while he's there. So I think that basically sums up. Thank you.
Mr. Olson, any response?
Yes, Your Honor.
Please.
Zach had been in my custody for 5 years and wasn't doing very good at Barn School. In fact, he was like leading the league in office referrals and wasn't getting like the proper attention he needed that he would be getting in Jewel. Okay, so he moved to Jewel, Oregon, and this is quite the drive. In fact, the road that I have to take to get there is the most brutal, bumpy, windy road I've ever been on. I was late 40 minutes one time. This is winter time, going through a road that are falling down in the road. People bring their chainsaws and chainsaw the road, the trees out of the road. There's snow, ice. It was a pretty crazy winter, and believe me, I have tried leaving earlier and earlier to get there in time. And the past 2 weeks I've done that, I'm still late. 2 minutes late, 6 minutes late. I'm sorry to be that late. The work that's been going on the bridge. I tried leaving earlier, and I was 6 minutes late last time to pick him up. And also Zach's sports. I have always been totally, every practice, I've always been like the coach's hand. I'm usually out there with the boys, helping out. I haven't been able to do that. The way they do sports is really different over there, it being such a small school. When his games have went on, I have been able to get to the ones that I could. Now, I did have some issues with my health where I had to use basically all of my vacation time and wasn't able to like just leave work, so I had difficulty getting to some of them. It seriously breaks my heart to not go watch my boy do sports. And enough with that. This declaration that I've read over is just basically like the two before this one. There are a lot of accusations, false accusations in there. I don't know. I know I have lost weight. I did lose my job. I'm working on getting another career going. My body just kind of gave out with doing the welding and the fitting all the years and all the overtime they used to push. And I just couldn't perform the way I used to perform, having to change my career and get into something different where I'm not using my body like I was. Zach, see, to my awareness, we're not supposed to talk about our cases with our children. Our last case, he knew everything that was going on. I don't know who was talking to him because he does have a sister, but he was totally aware of things that they're not supposed to be aware of. He should not even know some of the stuff that is going on right now, it blows me away of how he even knows this. Now I know he's been influenced by my girlfriend's son, whose dad is very, very vindictive. And I've seen, I mean, just flat out lies, just ridiculous, and brainwashing the kid. And it's, this kid says things that a kid that age should not say. I don't know. I feel that Zach is in a safe place. He always has been. He always will be. Yeah, I'm willing to give the UA. I don't feel like I need to go through and defend myself on all these. You know what? If you want to call my mother, she has a statement from my mother that says some stuff. My mother said, I did not say all of that, but I was concerned about your health too. And I understand that. And I don't like to have like people worry about me. My mom didn't know when I got COVID, and they took me to Portland. They took me to St. John's. St. John sent me to Portland. I didn't even let my mom know that I was going through that night, just my girlfriend, in case anything got really, really serious. And it was really serious, but I just don't need her to worry, is how I feel. I don't think anybody knew that I don't think it's any of Zach's mom and stepdad's business that I'm diabetic, that I take heart medication. I quit drinking and I lost weight. I thought I was supposed to gain weight.
Okay.
I don't know, Your Honor. I'm not here to waste anybody's time. Let's just get down to it. I mean, I'll take a UA. Let's like get over this.
Yeah, thank you.
You're welcome.
Ms. Steinweg, any response?
No, Your Honor.
Okay. So neither of you would be aware of this, but the court has recently adopted a local rule where before we take any other action on a parenting plan issue like this, we'd like the parties to go to mediation. That's in certain circumstances, this one qualifies for that. And so I'm going to order that you go to mediation. We will get you the address of the mediator firm. There'll be some cost, but it would be less than appointing a guardian ad litem at this point. It will, if you're able to resolve it at mediation, it will be quicker than setting this for trial and going through a trial. I'm going to order that you share the cost, but it's my understanding is the total cost is less than $200. I'm going to have my judicial assistant, whose name is Autumn, get a hold of both of you and just give you more specifics about how to set that up. Okay.
Okay.
So that is what I'm going to order at this point. I'm going to set a review about 6 weeks from now. I'm hoping that you'll go to mediation and be able to come up with a revised parenting plan. If you cannot, you're not successful, then we'll come back and we will address the adequate cause. And Mr. Buchanan is here. Yeah, I'm glad you're both here. I did not see that there was service. Let me just.
I turned it in, but I think I turned it in too late. I can bring in another copy if I need to. I copied it 3 times, so I had one, and then so you guys could have one. But yeah.
Well, let me. That you must have served Mr. Buchanan fairly recently. Mr. Buchanan, are you ready to go forward with the hearing today?
Yes, Your Honor.
Okay. All right. Very good. So then, Ms. Heath, why don't you go forward?
Okay. I don't want to the contempt of court is more of for me, it's more of a telling him that we've always had really good communication since it started. We've had moments where kind of communication went downhill for a minute, then it came back up. We've always communicated very well about our daughter. We were doing really good up until about February, and then it seemed like communication kind of went other ways, and And then I never saw this whole contempt coming. He took her that weekend and I was like, okay. And like, it was his weekend. He took her and it seemed like everything was okay. And then all of a sudden Sunday came and it came to, I got home from work about 6:15 and they still weren't there. Cause I usually work on Sundays. So I get home like 6:15 and I let them know that that's when I get home. And, no one was there. So I tried to call him, 3 times cause I was concerned, just making sure they were okay. And then I tried to text him and he got upset and told me I was harassing him when I was just concerned that my daughter wasn't home. So I did message his mother who was supervising visits, from last time. She was supposed to be kind of supervising a little bit at their house because he lives with her. And she told me she wasn't allowed to talk to me. And then I tried to call him again and he said, well, you can come and get her. I sent those text messages in. I turned them in with all the paperwork. But he said, you can come and get her. I said, okay, where are you? Like I said, I asked him where he was, like, what is going on? And then it took until about 8:30 at night. I finally got an answer. After I got the answer, it took a little bit. He gave me the address and me and my dad drove up there. I was more upset. I don't mind if in the summer when he can keep her, if he wants to do something, he has plans for Monday. He can keep her Sunday night and keep her into Monday and stuff, but she has school right now. And she just got over being really sick and everything. So she missed a little bit of school. And she's been having issues at school. So I've been trying to get them all straightened out. And we finally were getting on a routine. So it just kind of caught me off guard and was upsetting. I was more upset. Like, I know it's kind of hearsay because I don't have proof that my daughter said this, but she said that she was upset. She didn't know if she was coming back home. And I told her, your dad would not keep you forever from me, I promise. And because I know Gavin Buchanan would not do that. It's more of, I did the contempt because just the fact that I ended up having to drive 2 hours that night, picking her up, didn't get home till midnight. So she had to miss school the next day. And she was upset about that because she actually had a school party on that Monday and she was very upset. And then I'm just like, I don't mind him being late. That's okay. Because he usually communicates, say, hey, we got stuck in traffic. I'm gonna be late for pickup or drop off. That's 100% fine because he lives an hour and a half away or something like that. And so I don't mind.
What's the typical visitation schedule between?
Right now it's every other weekend, from Friday at 6 p.m. That way she can get out of school, till Sunday at 6 p.m. That way she can go to school the next day, get home in time to shower and get ready for bed.
Okay, every other weekend.
Yeah, and it's been great. And we have 1 week in the summer, and I'm hoping that goes okay. This was more just of a, hey, this can't this can't happen because it's not just stressful on me. Like, it did stress me out because that's like, it's my daughter. So obviously it's going to stress me out when I don't know where she's at, what's happening because no one's responding. But it was more of a stress on her because she didn't know what was going on. She was happy because her brothers were there, but she was upset because she didn't know what was going on. She didn't understand because she knows she comes home on Sunday at 6 p.m. And I know sometimes she doesn't want to come home right away because of the fact she does like spending time with all of them. She talks about her papa and her nana all the time. So that's why this summer I'm willing to compromise. Like, if he like when she doesn't have school, she's out of school June 14th. So when she's out of school, if he wanted to keep her an extra day or something, or a day or two, and like we compromise, we talk it out, I'm completely fine with that. I have no problem changing up the schedule a little bit. But if it's just with school, she cannot be missing school with school being almost over.
Thank you. Mr. Buchanan, any response?
Yeah, communication's been going really good. We've been able to communicate with each other every visit. And then as far as like when I get more than just the weekend, like I was supposed to get her for a spring break for I think like a week. I gave it to her this year and then she'll have it next year too. But we've been compromising on certain things just because I live like over an hour away too.
What happened on this particular day? Let me tell you my concern here. This is Ms. Goddard Heath. She had texted some before, but I'm going to start reading part of this. I need to know what's going on, or am I going to have to call your mom? You have our kid and it's in the middle of the night. She needs to be home in bed. So please.
But that was Saturday night.
Let me finish this. And then it says, and then Ms. Buchanan Heath again, I'm going to keep calling till you answer, or you pull in my driveway. And then the next one, where are you guys? Gavin, this is my kid too. I have a right to know if she's safe. You can't just say that you're bringing her back and then not answer me at all. It continues to get concerning. I'm going to call the cops to come knock on your door if no one answers me. And then the next one, I'm freaking out, Gavin. You said you were bringing her home. It's been over 2 hours and no one is answering me now. And then, are you bringing Annabelle today, or your mom? And then your response after all of that is quit calling. So I'd like you to explain that.
She was blowing up my phone to where I couldn't even use it in the middle of the night as I was sleeping.
Was there an agreement that Annabelle would be staying with you that night?
Yeah, it was my weekend. It was Saturday night.
That was Saturday night?
Yeah.
I have. Sorry.
Okay, let me just hold that thought. Ms. Goddard Heath, go ahead.
That reason is because I got a voice message. I can't attach voice messages, so I'm asking that he does not send voice messages to me anymore. Because I can't prove those to you guys because I can't attach them in a document. But I got a voice message saying, I might have to bring Annabelle home tonight. And then it said, I punched Charlie in the face, which is his stepdad. And so I got concerned. I was like, okay, that's fine. Just bring her home. And that's when those messages started, because all of a sudden it's 2 hours later and he's not answering me. Obviously he was getting my calls. I just wanted an answer saying, oh, never mind, I'm not bringing her. And I would have been like, okay, that's fine. I was concerned for her because of the whole him sending me that voice message, and I wish I could attach it. I tried, but it just wouldn't let me like change it or anything. It's just, yeah, it's an iPhone. iPhones do the voice message, and it's frustrating. So I'm also requesting that he can't send me voice messages anymore. That's all text messages or phone calls. But he said he was going to bring her home. That's the only reason I sent those. Otherwise I would have not I never try to bother him. I'll say, I hope you guys are doing good. Or let me know, like if Annabelle was sick one time when she went up there, and I said, let me know how she's doing. If you want to, like I said, let Annabelle know I said hi, or see how she's doing. And then normally I leave him alone when it's his weekend.
Okay. I don't know if either of you have been pulled over by the cops for speeding, and at the end of the discussion, they let you off with a warning. That's what I'm going to do today. All right. It was clear looking at these text messages that Ms. Buchanan Heath was seriously concerned about what was going on with Annabelle, and she was expecting that Annabelle would be brought home. And after all of this concern, I mean, one of these is I'm freaking out. That should communicate something. The first message is quit calling. And then the second message is you're harassing me and I'd like it if you'd stop. Well, the right response is we're in Newburgh and everything's fine. That would have satisfied Ms. Goddard Heath, and she would have known what's going on. And I'm giving you a warning because both of you have told me that communication is great between you, and that the visitations are going well, and that you have flexibility in your relationship with Annabelle. And I think all of that is positive, and I don't want to do something that somehow hurts that. But I am telling Mr. Buchanan that if you get similar texts in the future, you need to answer them appropriately and just say, here's where we're at, and let it. So I'm going to deny the contempt. But again, I'm giving everybody a warning. And if a similar situation comes before me on your case in the future, I will take into account this situation. Okay. All right.
Thank you so much, Your Honor.
Good morning. Good luck. Mr. Chapman, you brought a motion for contempt relating to the exemption, so I'll let you go first.
Yeah, so I went to file my taxes, and I had on the final divorce and all that paperwork, it included that I get to claim Brody and she gets to claim Harley and Tatum for the years or whatever and ongoing. So I went and filed my taxes, and with only claiming just Brody, and they came back as rejected, and it said on there that this dependent has already been claimed for this year. So you have to refile, do all your work again or whatever to refile. So I brought it up to thinking it should be going through the contempt order because it's going against the plan. And I mean, now that I had to refile with not claiming Brody, I am owing money, which I was going to get back $2,222 with claiming him, and now I owe $778. So I think there needs to be some kind of something figured out.
What was the amount of the exemption with him?
The amount of the exempt, well, it's $2,000 per kid. So
No,
when
it's
I
not.
didn't,
Go ahead.
so when I when I had Brody and claimed him on my taxes, the amount that I had that I was going to get back was $2,222.
How is there a $2,900 swing in your taxes when the exemption is only $2,000? Do you understand? Can you explain?
So that's all so that's the information I put in on my taxes, and I did it with him, and I was getting back $2,022, and then I did it without him, and I owe $778.
Was that like through TurboTax, or did you go to some agency?
That was for TurboTax.
All right. Ms. Chapman, any response?
Yes, Your Honor. I prepared something, but also to touch on what he had just stated. The tax credit for children is not $2,000 this year. Mr. Chapman also does owe the IRS taxes, I think $3,000 from last year's taxes when he filed, that has nothing to do with me. So all of that is highly unbelievable. But I myself was very shocked, as well as a bit humored, when I received the contempt papers from Mr. Chapman. Again, very untimely, as the papers, as you have seen, were filed on March 31st, and I did not receive them until April 14th after the court was closed. So 2 weeks after filing the papers, and also leaving me with only 2 days to speak for myself. So therefore, I have not gotten to file what I could be yet again. Your Honor, Mr. Chapman's retaliation and manipulation efforts again show the court the frustrations I have had throughout the course of almost 2 years, and especially with all of the true contempts I have had to file recently on him, which he continuously got out of with lying to the court and manipulating the system. Not only have I sent him pictures of receipts with totals and calculating his half of baseball and softball costs on March 10th, and he has ignored every one of my efforts to receive his court-ordered half of those costs. So I, during a phone conversation, informed him that I may end up having to file him in contempt for that. But I really did not want to have to bring this all back to court. If going back and forth to court was something I wanted, I would have brought him not paying his half of school clothes, school supplies, football, basketball, wrestling, him not having the kids on his insurance, and many other things he does not hold up his court-ordered end of in front of the court. But I have not. I have only brought a very few amount of things. I have also learned that after all the last, I believe, 5 contempts, he has yet to face any true punishment. And considering he finally, after being forced to by almost being given jail time, paid me his first spousal support payment, and considering he finally, after being, in an entire year of being ordered where the amount was even cut in half for him at our last hearing, I had faith in him that maybe this time he would do his part for the kids and just pay his half of the sports fees. So I waited, and a week later, to file the contempt on that. And a week later, he serves me with this, almost trying to beat me to it or retaliate on what I was just filing in contempt for a month prior. This also being the very first paper he's filed in almost 2 years. I have, the court order where it got ordered that he claimed Brody on taxes was signed on July 19th, 2022. Therefore, that was a little more than halfway through the year. And my tax professional stated that since it was halfway through the year that it was ordered, that it would be next year that it would play into effect. And I financially provided for him and our other two kids that I was to claim him because I provide every single thing for them. I also have something to bring to the court that is not relating to what we are here for today. That is an even more serious thing. I just have not got the time to do so, as this was just brought to my attention very recently. That is another contempt. I could have asked for an extension for today, but I don't think it's needed to waste more time. And I think this all speaks for itself. Mr. Chapman owes me upward of $24,000. So him asking to take money from the house his kids live and from the person that raises them with no help physically, emotionally, financially, or any of the other things without the force of the state from him truly did break my heart and make me physically sick. Thank you.
All right, Mr. Chapman, any response?
Yeah, I mean, there was a lot said that, I mean, we're here about, figuring out the whole, who's claiming what and when and all that. And on the paperwork, it says that, I am to claim Brody, for the years, and she's to claim our two daughters for the years. So that's where I'm at right now. And like I say, any money I get from that, like I stated on there, I would be paying, and it would be taken off my amount. So that's where I'm, coming from. I just, now I owe more money. You saw my paychecks. You saw what I make and what I bring home. I mean, I'm doing what I can to live, and, she's got her boyfriend there at the house that, works full time, and, she's not the only one that is around the house. So
Why my
I'm
car's
just here on the order.
any day getting rebuilt.
I'm just here on the order
I'm gonna
of,
let Mr. Chapman finish.
I'm here on the order of, me claiming Brody, and I go to claim Brody, and I get rejected, and that's on the final paperwork that says that I claim Brody. So.
All right, so I'm looking at the June 15, 2022 decree of dissolution, and it says Bryce Chapman claims Brody Hancock's every year. There's also a box below that says, although the personal tax exemptions are currently suspended under federal law through tax year 2025, other tax benefits may flow from claiming a child as a dependent. As I've indicated, I'm not sure I understand how a $2,000 exemption nets somebody $2,900 in benefits, but I'm willing to look at that. And I'm sorry to make you come back, but what I'd like to do is come back on May 3rd. And Mr. Chapman, you're going to have to run on TurboTax those two scenarios that results in that difference so that I can take a look at it.
Okay.
And so I want to consider that. I'm not finding contempt. I will decide if I'm going to do that at the next hearing. But right now, I have no basis to make any kind of monetary allocation. And so I'd like to look at that before I make a decision on it. Okay. So,
Okay.
And those should be filed what we call under seal with the clerk, which means they'll be private. And so your personal financial information will not be open to the public. Okay. And then provide a copy to Ms. Chapman. That should be done by early next week at the latest. And then we'll see you both back here on May 3rd. Okay.
Your Honor, I have one question.
Sure.
When he does do taxes, he owes like taxes to the IRS, and considering he owes so much back child support and back spousal support and stuff, it goes to me anyways. So I don't understand. And also, I only got $2,600 in taxes. So he's under this impression I got like $10,000 and I did not. So this is all crazy to me. Like, I'm literally about to lose my car, and he's asking to take money from his kids who they're like, I don't know. I guess we'll
I understand
back.
that.
This is just
Understand.
cracking me up and grossing me out, and it makes me want to puke.
Ms. Chapman, I think I understand
awfulness.
your position in this case. As I said, I haven't decided if I'm going to find contempt yet. If
That's
you'd
okay.
like to
I'm just upset
file-
over just the fact of it.
If you'd like to file a further response for me to consider
I honestly just don't even care anymore.
by May 3rd, you can do that.
It's okay. I don't care anymore. I'm done.
Good morning. All right, we'll see you back here then. See Mr. Gorski.
Thank you.
So you're well, let me see here. There was a motion or an order of default entered in this case on March 2nd, 2022. And I guess Mr. Gorski had filed what was considered a notice of appearance.
And then he failed to show. So we had found him in default because he didn't show and was not in agreement. He has since gone back to prison since he was released. So just kind of looking to finalize things.
Okay. If he had not appeared, there's a statute that requires that if a year goes by between the order of default and the actual judgment, that you'd have to reserve him. But since he's appeared in this case, at least on one occasion, then that statute does not come into play. And that's, I was just thinking through that in looking at this. So based on that, I'm going to go ahead and sign your, well, here's the other issue. So if he's appeared, he's entitled to at least having you mail to him the documents. And I don't think you've done that in this case, right?
I mailed him the proposed parenting plan, not the final document that I met with the court.
Was there any change between the two?
No.
No. Okay. He's in default. I'm going to go ahead and
Have a good day.
sign these documents.
Thank you, Your Honor.
All right, that brings us to Tanya Hansen and Joshua Gray. Tanya Hansen and Joshua Gray on a UCC JEA hearing. During the break, Judge Velour and I spoke. I will say that we agreed that Washington and particularly Cowlitz County should retain jurisdiction of this case. And then Judge Velour, why don't you discuss what your intent is regarding the Lane County action?
So in light of this decision, it is appropriate to vacate the immediate danger, order. So that will not affect the ongoing case. And I will then also dismiss the initiating petition. And my understanding is Commissioner Nelson's going to prepare an order. So I will do those things once the order is actually prepared.
That order will probably take me a couple days, and then we'll send it to Judge Velour in Lane County, so that emergency custody order probably will not be struck until 2 or 3 days from now. Just so you know, Ms. Hansen. My records show that we have a review hearing tomorrow in your case. So it sounds like I'll see you then, and we'll have to determine what we're going to do going forward. Okay.
Okay.
Ms. Hansen, any questions?
No, Your Honor.
Okay. Ms. Corey, any questions?
Was that phone number a good phone number?
No, thanks for asking that. We called it came up with a busy signal, but it sounded like it had been disconnected. That kind
Okay.
of signal.
Okay. I'm still looking for a way to contact Mr. Gray myself.
I mean, feel free to try it, but I suspect you're going to find that it's.
I'll try it just to document it.
Yeah. Okay. Thank you everyone for participating in today's hearing. And I think that brings it to a close.
Thank you for hosting.
Yes. Ms. Corey's here and Ms. Hanson's here. And I was not expecting Mr. Gray, honestly.
I did get a message from him with a phone number.
A text from him?
Yes, this morning saying that his phone won't connect to Zoom.
Okay. So you have a phone number that's good for him?
As of right now, yeah.
Don't tell me we're on YouTube and I don't like private numbers shared, but I would like you to give that number to Ms. Corey.
I actually also heard from Mr. Gray this morning and spoke with him briefly, reminded him of this this hearing, and I do have the phone number also.
Okay. All right, good.
Would it be appropriate, Your Honor, if we set this compliance hearing back? Because really, I have just been able to be in contact with both parties and just received the order appointing the other day. Can we set that compliance out a few weeks?
I'm sure we can do that. Sure, we can do that. And we'll pick a time in a moment here. So based on our hearing the other day, the emergency custody in favor of Mr. Gray is going away. I think I need to take a couple steps to get to a place where the child, I would like the child moved back to Ms. Hanson at this point. So I'm going to enter a bench order that transfers custody to Ms. Hanson, and then that will be subject to any visitation plan that we put together for the future. And I'd like to come back on May 3rd at 9 o'clock. And if custody has not been transferred by that time, then I'm likely to enter a contempt hearing or a contempt order, which then I believe will allow law enforcement to get involved in transferring the child. But I don't know that I can do that today. Okay. What I'm hoping is that Mr. Gray gets the message that I've done that he'll do it voluntarily, and maybe May 3rd, we discuss what kind of visitation arrangement we want to enter into, if any. I'm a little concerned that I feel like he misrepresented facts to the Lane County Court in order to get that emergency order. And so I'm a little concerned about why that's the case. Okay. Okay. So Ms. Hanson, anything you want to add or anything that you'd like to say?
Not at the moment, no.
Okay. Ms. Corey, do you think that makes sense?
It does. It does. And I will probably have been able to be in touch with both parties and give you some idea of compliance at that point also.
Do you want compliance to go out to mid or late May?
No, it's not that. I mean, basically, I'm just checking in and letting you know that both parties are cooperating, and I think I can determine that in the next couple of weeks.
Okay, then we'll just set that for May 3rd and then see how we proceed then. I'm sure I'll set additional hearings after May 3rd, but I'm hoping that we can get everybody's cooperation going forward. Okay. Okay, so I think that's it on that hearing. I'll enter that order. It may not be today, it'll probably be tomorrow when it gets entered. Okay.
Okay, thank you.
Your Honor,
Yeah, yes, Ms. Corey.
how will, being that Mr. Gray is not here today, how will he be notified of this?
Well, I'm hoping if you talk to him or if there's been a text with Ms. Hanson that one of you will say, look, the court ordered that you transfer custody by, immediately, I think you should say.
Okay.
And
Would it be
let's
better if I did that?
That'd be fine. And let's work out a way that can be done. And then he needs to know to show up on May 3rd so that we can discuss visitation.
Okay.
My intent is not to cut off his rights as a father, but the mother's gone a long time without seeing her child at this point. Okay. Thank you. I'll see you back here in 2 weeks.
Thank you, Your Honor.